And hello.
Hello again, everyone. Zachary Lawrence of Parkside Property Management with my friend Dennis Block. We're here on the Landlord Tenant Radio podcast to discuss something that this guy knows a whole bunch about, and that is the landlord-tenant relationship. And Dennis, let's get right to it. How are you, by the way?
I am fine, and I'm really happy that we could do this podcast.
We're both wearing black. This is for the Me Too movement, right?
But I'm great. Oh, wait a second. You're great too.
We're both. Anyway, we support the Me Too movement. You'll get the women vote in the next election. Okay.
I did want to talk about a little bit about the Costa Hawkins bill. I want to thank all of my clients and listening audience in that we defeated the bill that was in front of the House Assembly for California. And we all know that the Costa Hawkins bill would allow other municipalities to institute rent control and do away with vacancy decontrol.
Dennis, there are listeners out there that may not be familiar with Costa Hawkins. Excuse me. Can you, in plain, simple English, can you explain to them what that is?
Very simple. Costa Hawkins is a law that's been on the books for many years in the state of California. It was really one of the true and few laws that helped landlords. It stated that if a municipality had not instituted rent control by 1995, then they wouldn't be allowed to institute it now. So, for example, Glendale would love to have rent control, but because of Costa Hawkins, they couldn't. And now we're seeing a floodgate of municipalities and people marching on city halls trying to institute rent control for their city, but unfortunately for them and fortunately for the landlords, the Costa Hawkins bill prevents a municipality from instituting rent control. It also prevents a municipality from doing away with rent decontrol. That is, once a tenant vacates the unit, a landlord is allowed to raise the rent to any level that they like, and
market level.
To market level. And of course, Costa Hawkins gave them that right. Otherwise, you could have a situation where your tenant moves and you still can't raise the rent. So there's been a foot in the Senate in California to try to get away or defeat this and repeal this wonderful act. And there was a vote that came to an assembly committee. And we had sent out, I sent out 4,000 emails, and I know a lot of the apartment associations did, and of course that was stalemated, and therefore Costa Hawkins gets to live for another day. The problem is that it's going to be an initiative on the ballot as of November 2018, so we're going to have to do a lot of work so that we can defeat that. And what I've been beating the drum, and I'll beat the drum again in this podcast, is that if you do have a non-rent controlled unit, make sure that your rents are up to market value. Because once a municipality institutes rent control, you're going to be stuck with that level that you were charging. So if you have a tenant right now and it's not under rent control, raise it to market level.
Now, Dennis, you and I have been on the radio for 20 years, and one of your tools to circumvent rent control, and we even discussed this on our DVD called How to Beat Rent Control. You like the way I plugged the DVD in with the body of the question? Is
I appreciate that.
Brilliant?
Yes.
Okay. Is to build in increases with your existing lease. So I understand that you're cautioning our listeners to get market rents for their units. But in the event that Costa Hawkins dies, would it not behoove landlords for you to recommend to them, look, if you're going to create a new lease for a new tenant, protect yourself and apply what you and I refer to as the lease discount program?
Yes, that is possible.
Explain to our listeners what I'm talking about. Because quite frankly, I don't know what I'm talking about. I'm kidding.
No, of course you do. No, the lease discount program basically states where you set a rental amount in your lease agreement that's higher than what you really want. For example, if you wanted $1,000 for your unit, put in the rental agreement $2,000, but then give them $1,000 off for the first year and $900 off for the second year and $800, etc. This way you're getting a 10% rent increase.
Okay, quite the skeptical landlord here might be saying, and I'm going to adopt the position of the skeptical landlord. Well, wait a minute, Mr. Block. It can't be that simple. I mean, the rent control is the law, and here you are telling me that there's a way to basically saying, you know what, I'm not concerned with rent control. I'm going to draft a document that supersedes the law of the land.
Well, I mean, based on the way most rent control ordinances are written, I believe that that would be proper as long as it is spelled out clearly in your rental agreement. However,
has it been challenged in the courts?
it really hasn't been challenged in the court. Santa Monica has a specific rule that states that whatever you pay for your first month's rent is really what your rent is, regardless of the terminology of the who was that who walked in?
So the lease discount program does not apply to the city of Santa Monica. What other municipalities would it not apply to?
Well, that's the only one. However, getting back to I think what the issue is, which is assuming Costa Hawkins is repealed and municipalities can now start rent control, my suggestion to people that have non-rent controlled units is to make sure that you go through each one of your rentals, make sure that you have raised the rent to market level. This way you're protected. If rent control comes in and they give you 3%, but you're at market level, you're basically going to be okay. The other thing that you need to be concerned about if you have a non-rent controlled unit is that if you have a tenant that is what I call a malcontent, that's one who just gets on you, even if he's paying full rent, but he's always asking you to fix this and that much more than anybody else, and just has
a high maintenance tenant.
High maintenance tenant. That would be a tenant that, if he's on a month-to-month tenancy, that you might want to consider terminating, because once it's under rent control, you're going to have a very difficult time in terminating his tenancy unless you have good cause. Okay. So, once again, this bill is going to be coming up in November. It's going to be an initiative on the ballot. So we're going to do a lot of ground support to see if we can defeat it. But right now, while you have the chance, if you have a non-rent controlled unit, be sure that you raise your rents to market level, get rid of malcontent tenants. Take it away.
Your drumbeat here is raising it to market level, but we digressed a little bit. We were on this lease discount program, and you endorsed it, but I detect a little bit of reservation of your endorsement for this program, and you're going to be getting calls. This podcast is broadcast all over the world. You're going to be getting calls. Say, Dennis, you talked about the lease discount program. I'm a landlord in rent control Los Angeles. I hear your concerns about Costa Hawkins. Can I use the lease discount program without worrying that it's going to nip me in the butt later on?
Well, yes, but I don't. I think once you rent the premises out, if you're renting it out for market value at that point, I don't think there's an issue, and I don't think that we need to really avail ourselves of the rent discount program. It might be in some situations, but in most situations, if you rent it out for market value, you're going to be fine. Mm-hmm. And that's what the issue is.
Do you still support the rent control landlords out there to draft a separate commercial parking agreement, regardless of how much they're renting their units for, and regardless of the Costa Hawkins issue?
I think it's smart to do a separate parking agreement, even in rent-controlled areas, especially. And who knows whether your non-rent control building will become rent control.
Tell our listeners why.
If you have a parking agreement is not going to be under any rent control because it's going to be commercial in nature. And this way, if the tenant's giving you a hard time, you can always raise the rent on the parking space. You can also terminate the tenancy on the parking space
without having to give them a reason.
That's correct, because it's a commercial lease. So by separating it, it gives the landlord much more power, and I recommend doing that for any rental.
Okay, Mr. Landlord, you just served me with a 30-day notice that you are taking away my parking rights. This unit came with a parking spot. I now claim that the value of my unit has been reduced. There is a legal concept called the diminution of value. Can you talk about that a little bit, please?
Well, I can, but it's not applicable because in this situation, you have a separate tenancy for the apartment unit. you have a separate tenancy for the parking space. So the tenant cannot make a credible argument that by serving a 30-day notice on the parking space and removing it, that somehow his apartment is diminished.
Well, wait a minute, Mr. Landlord. When you advertised for this unit, it said parking, and I relied detrimentally.
I don't think you read it. I never said parking in my ad.
Excuse me, the Craigslist ad that you put in, just go with it, said parking. Okay, it was one word, parking. Now, when I signed the leases, commercial or residential, it was my understanding that I would be entitled to a parking agreement. Now, you are taking away something very valuable to me. Now I have to wake up at 5 o'clock in the morning because I have to park on the streets, and on Wednesdays I can't park on the streets. You know where I'm going with this. Please address it. Diminution of value.
Okay, but what we were talking about in terms of assuming I had put that into my Craigslist ad that it is parking.
You did.
And I'm saying assuming I did, then, but the issue is that's just negotiations, that's just offers. The actual agreement stated what it stated, which is I'm renting you a unit, an apartment unit for X amount of dollars, I'm renting you a parking. They're two separate agreements. I did not. You chose to sign it. If I want to take it away, I can take it away, and it has nothing to do with the value of the apartment.
Have the courts weighed in on this? Have you ever had a case come across where the tenant claims diminution of value even though he had a separate parking agreement?
I have not ever dealt with a case like that,
Okay,
and nor do I think that any court in the land would rule in favor of the tenant on that type of
So
case.
Judge Dennis would basically throw it out saying, you signed a commercial agreement, you're out of here.
I wouldn't even throw him out. I wouldn't let him in.
You wouldn't let him in. Okay, very good. Speaking of diminution of value, we have at Parkside we had a city inspection of one of our units, and the inspector basically said, look, you've got a ceiling fan and you've got these smoke detectors, but the blades of the fans are too close to the smoke detectors. Now, the landlord obviously has two choices. He can either remove the ceiling fans and keep the smoke detectors where they are, which is the less costly option.
Exactly.
Or he can hire an electrician, pull out the existing smoke detectors and relocate them. Now, if the landlord elects the more economical option, okay, of removing the ceiling fans, and in my hypothetical, if there is proper ventilation in the unit that satisfied code's requirement, could the tenant argue that there is a diminution of value in this particular unit? Because, hey, when I first saw this unit, I said, look at these beautiful ceiling fans, and now you're taking them away.
You know what? It's funny that you should say that, because I had the exact same issue in my building. And what we chose to do was to remove the ceiling fans. And the truth is that I can see that an officer or an agent at the rent stabilization office could declare that the premises have diminished in value and try to take away a certain portion of the rent.
What would a judge say if the tenant pursued it and said, hey, you took away my ceiling fan?
I think with the liberal nature of the judges that we have, I think that they might find that there is a slight diminution in value and maybe give $10 off the rent.
So basically, you're suggesting to our landlords out there, if you have a ceiling fan and it's too close to your smoke detectors, and you don't want the expense of removing the smoke detectors, you prefer to remove the ceiling fans, buyer beware, because this tenant has a good argument for getting a rent reduction, and in the long run, it might be cost effective for you to move the smoke detectors.
In our situation, the building inspector said that we didn't have a permit. Now, I just bought the building 3 years ago. Those fans were there. He said that they were not permitted. So based on that, we said, well, we're not legally allowed to have it, and we removed it.
Well, that is another issue. But assuming that the tenant moved in, the fans were permitted, and the smoke detectors and the fans collided with each other, your recommendation is to keep the fans and move the smoke detectors.
That would be accurate.
Okay, very good. Dennis, I want to talk to you about something that I call the, let me just follow up with one thing. If the building has a swimming pool, and then you serve the tenant a notice saying, we're draining the pool, diminution of value.
But draining the pool.
Draining the pool. I don't want the headache of
Oh, so it's permanent.
it's a swimming pool
Okay.
that was operating when you moved in, and now you get a notice saying we're draining the pool. We don't want the liability. We don't want the maintenance. We don't want the headache.
No question that the rent stabilization ordinance for the city of Los Angeles would declare that that's a diminution in value. They actually have what they call the regs, the regulations, where they give a dollar amount. They have a range for if you take away a parking spot, if you take away a pool, if you take away a laundry room, if you take out an air conditioner. These are all under the code for the city of Los Angeles, where if your rent was, $1,000, it's going to be reduced by $50 per month because you took out the pool.
Where can the landlords find that menu of dollars that you're referring to?
I actually have it
on his website. This man has everything on his website.
Actually,
you have any girls' telephone numbers on your website? Maybe I could log on.
Well, I don't think you'd want that.
Okay.
But actually, it's not on my website. But maybe I will put it on my website. But we have it as an internal document, or you can look for under the rent stabilization ordinance. Look at their regs for diminution in value, and they do have a laundry list of the value if you do try to take away a service. Sometimes it's worth it to the landlord that they'll take away the common area patio, and because they want to do something else with that, and it's worth it for them to give a reduction in rent.
Okay, so the reduction has to comply with the reduction offered by the city, or articulated by the city.
Yeah, and they'll have, for example, a range of parking somewhere between $30 to $90, depending on how much off-street parking exists. If off-street parking is very tight, then it's going to cost you more because you're going to have to maybe find a place where you can park your car.
It's like a game show.
Yep.
Unbelievable. Dennis, we have a building at Parkside, a 15-unit building, and we have a boiler room, okay? And tenants...
Did you lease that out too?
No, it would be a good source of income, though. If you're looking for a place, you'll let me know, okay?
I will.
All right. So what's happening is the tenants are starting to use that as a storage facility, okay? And
do you not keep that room locked?
We do. We do, okay? They found a way in. My question to you is this. If they've been using it as a storage facility, unbeknownst to the landlord, and the landlord discovers that they've been using it as a storage facility, what are the landlord's rights in that particular situation?
Well, the first thing I would do immediately is to serve the tenant with a letter stating that they have improperly stored their personal property in the boiler room and to remove it. I'd give them, let's say, like a week to get rid of it. If that doesn't occur, then I would check the rental agreement. Most rental agreements state that you cannot store personal property outside your unit.
Does your rental agreement say that?
Absolutely. So in that situation, I would serve a 3-day notice to perform or quit. By the way, that website is evict123.com.
We're 20 minutes into the podcast. This is the first time you've waited that long to plug your website. This is historical.
How many times did you say Parkside 123?
I haven't yet. I haven't.
Well, really?
That's
Parkside.
Correct. That's correct. We're in a little contest here, folks. Okay.
All right. So if he doesn't remove it, then you would actually have the grounds to evict if he doesn't remove it within the 3-day period.
Interesting, folks. What he's telling you now is that you can evict a tenant for a breach of their duty for violation of a common area rule. It doesn't have to necessarily be inside their unit.
No, of course not. For example, I don't think it's a surprise to you if you had parking or no parking in your rental agreement and a person brings a car and parks it in a spot. Of course, that would be grounds for eviction. It has nothing to do with the interior of their unit.
Okay.
But sure, we have it where they put barbecues and slides and all kinds of stuff in the common areas or even in this location. It might not even be legal in the boiler room.
But Mr. Landlord, you have a swimming pool and we're just using it for our kids' floaties and whatnot.
And
have a heart, Mr. Landlord.
And maybe I will have a heart. Maybe I don't care. But the reality is if I do care, you don't have the right to use my property for your storage. That's why they have public storage areas, or store it inside your unit, or maybe we give you a locker and you are outside that locker situation. So bottom line is that would be a good case for eviction.
We have, Dennis, 9 minutes left. And in the 9 minutes, I want to ask you about an eviction case, and I call this the $15 tenant, okay? We increased our rents in January. The tenant sent us the old rent. He didn't give us the additional $15. We increased it by 3%, okay? We served him with a 3-day notice. He hasn't paid the $15. I think this is relevant to all the landlords out there. Is it worth my time and my trouble, and will I prevail evicting, let's call him the $15 tenant?
Okay, so the scenario is that you raise the rent by $15, you serve the proper rent increase notice, and the tenant, for whatever reason, maybe he didn't get it, maybe he didn't understand, or maybe he just doesn't care.
Oh, he got it. He was served with it.
All right, so in that situation, you accepted his rent, and now you're serving a 3-day notice for $15.
Correct.
We have evicted tenants for $3 and $5
Have you
and $10.
have you prevailed?
We have evicted. We have removed those
Okay.
tenants from the property.
Okay, let's talk about the cost of doing that. The tenant owes you $15, but this guy, come on, let's talk candidly. He's going to lawyer up. The jurisdiction is downtown. He's going to get pro bono legal assistance. He's going to want a jury trial. I don't have to spell it out for you.
You don't have to spell it out for me, but if I've got a tenant that the rent is way under market value,
Correct.
And if I evict the tenant, I am now going to be able to get market value. So let's take a scenario where I raise the rent from $850 to $865. Our friend tenders only the $850, and I'm serving a 3-day notice for the $15.
Right.
As a suggestion to landlords, I would not serve a notice for $15. What I would do is I would not have accepted the $850, and then I would have served a 3-day notice for $865. But we're going to use.
Is that a game changer? Is that a game changer that the landlord accepted the rent that was short and then served the $15?
I think it's easier for most courts to evict on the basis that, hey, he tendered me a partial payment, I sent it back, I asked him to send me the full $865, and he didn't do it. So in that situation, I think it would be a better approach. But let's go to your example.
Yes, please. Yes, please.
So in your example, I took the $850 and I served a $15. So what this person is saying is, yes, can he get an attorney? Can he get a jury trial? Can he do all this? But the reality is that how much is this going to cost versus what am I going to get back if I win?
I understand.
Let me finish my thought. You might understand, but I want the audience to understand.
Thank you.
And the situation is that if I go to Las Vegas and I put $2,000 down on a roulette wheel, red or black, and I win, I submit to you what I'm going to get is $2,000 only. That's it. One time, and I walk out. If I put a couple $1,000 down on an eviction case and I win, that rent, which is now $865, really could be $1,865, and I'm going to get $1,000. I'll let you speak. I'm going to get $1,000 more for the rest of my life. So just on the odds of it alone, whether I'm going to win or not, if I got my foot in the door and your rent is low, now if you're going from $3,000 to $3,015, I agree with you. But if I could get an extra $1,000, the math on this indicates that, hey, you know what? Maybe I'll win, maybe I won't, but look at the return. This is like Vegas, except I keep winning every single day. Go.
Okay, you're telling our viewers that if your tenant owes you $15, and this is a real life situation, I'm not just hypothesizing here, that it is cost effective for them to spend thousands, your own words, thousands, what could be thousands,
yes,
on an eviction, and they should be comforted because Dennis Block is telling them that you will prevail.
Except you made the scenario that this is, in every single case, going to go downtown, free attorney and a jury. And let me tell you what happens in most of the cases. That's not what happens. In most of the cases, I file a lawsuit, which is just a few $100s, and what happens is the tenant doesn't respond to the lawsuit. We win the case by default, and now the client, the landlord, is now looking at getting an extra $1,000 a month for the rest of his life. Now, let's pretend that the tenant contests the case without an attorney. Again, we're going to go down to court, and in that kind of a situation, maybe the tenant's going to show up, maybe he's not going to show up, but we're definitely going to be able to prevail in that situation in most cases. If he's with an attorney, and he is asking for the jury, the worst case scenario, but that's it. It's just 1% of cases. It's not every case.
I'm giving you
worst case scenario. And I understand that. So if in fact we go through this, there is a chance, of course, that we can lose. We do. I really like
the landlord loses. You
yes,
don't
there
lose.
is a chance that the landlord could lose. There is, but I actually like this kind of a case in front of a jury more than I do in front of a judge, and I'll tell you why. A jury, I'm going to give them specific jury instructions of, did the tenant pay the $15 within the 3-day notice period?
No, he did not.
And if he didn't, there's no wiggle room. A judge has much more wiggle room when it comes to making a decision on these kinds of cases and can try to find any reason to get out of the case. With a jury, we actually have a better shot, even though it is only $15. But I'm telling you, the risk versus the reward is astronomical in these kinds of cases. We don't know what's going to happen. So if you have a situation where a tenant shorts you in the rent and the rent is well under market value, number one, don't accept it. If you did accept it, serve a 3-day notice for the difference. I still think it's a very, very worthwhile endeavor that the risk versus the rewards are so off the chart that it's worth doing it.
Okay, Dennis, one last question and we'll wrap it up. You just gave me some very sound legal advice, okay? I'd like to hire your firm to
let me get a retainer agreement.
To represent me quickly for this $15 tenant, okay? We pay your fees, we go to court, and we lose, okay? This is a possible scenario, okay?
Of course.
Okay, now, I'm the landlord, I'm out of pocket thousands in legal fees, and this tenant is still there.
Right.
Mr. Block, who's the winner and who's the loser here?
In every lawsuit, somebody is a winner and somebody is a loser in these kinds of cases. Don't forget that if you have a case that starts off as a few $100s, and then you see that legal aid or another law group jumped on, does that mean that you have to take the case to the end, to the bitter end? Or can you just cancel it at that point and that's all you're out? And of course, that's a possibility too.
But I don't want to put my feet in the water without jumping in. I'm either in or I'm out.
That's nice. So the issue is, if you want to reap the rewards, then you have to risk the losses.
Okay.
Okay, because the rewards are going to go to who? To Dennis Block?
The lawyers.
The rewards, my friend.
If the landlord loses, in court, the winners are the lawyers and the losers are the landlord. Let's call it for what it is.
But what if the landlord wins? Then the winners are not.
That's right. But you're changing the subject right now. I'm saying
I'm talking the whole subject, my good friend.
Okay. Best case scenario: tenant gets evicted, rents go back up to market level. Landlord gets his money back over a certain period of time. Worst case scenario is that the landlord is out $2,000-3,000 in legal fees, and the guy still stays there.
And the issue is, going in what the risks are and what the rewards are, and that's a decision for an astute property owner.
But you would still recommend, given the hypothetical facts that I gave you, okay, the $15 tenant, that a landlord would have a better than 50% chance.
Without question.
Without question.
And much better than a 50-50 chance. And I think any astute businessman, and I deal with a lot of players out there who know this game. And for this game, they will take it to the nth degree because they know that the rewards are much better. The other side of the coin is you're in court for that $15 case, and then we will wrap it up. We are in court for this $15 case, and the other side comes over and says, I'll move, but I want you to pay me $5,000.
Yeah.
Now, in that scenario, you're there. You could pay the law firm more money to do a full jury trial, or you could settle it. And if you settle it, you know what you're going to get. You're going to get $1,000 more, potentially, at least in this fact situation. And maybe it's worth it to pay these people to move, because you don't want to take a risk. But you don't get to this point if you don't take the chance in the first place.
You got to break some eggs to make an omelet.
You got it, sir.
Okay. Since you're making book on lawsuits, who do you like in the Super Bowl?
New England.
You like New England. Okay, I'm taking Philadelphia and steak dinner.
You got it.
Okay, brother.
Hey, with that,
yes.
I'm going to wrap it up, and then I'll turn it over to you.
Wrap it up.
Hey, I hope you enjoyed the podcast on this January 30th, 2018. My good friend Zachary Lawrence of Parkside Property Management. His website's parkside123.com. And of course, Dennis Block, my website's evict123.com, where we have all these forms, and also you can see these podcasts. And if anybody needs to reach our office, we don't charge for a phone call, and it is, as if you look behind me, it's 1-800-77-EVICT. That's EVICT.
That's it, folks. I'm Zachary Lawrence, Parkside Property Management. See you next time on the